For those of you online, I'm Alan Carey. I'm the Director of Sphere Education Initiatives. It's a pleasure to host you. Tonight's conversation is going to be with Jameel Jaffer. I'm very excited to have him join us. Jameel is the Executive Director of the Knight First Amendment Institute at Columbia University. Under his leadership, the Institute has filed precedent-setting litigation, undertaken major interdisciplinary research initiatives, and become an influential voice in debates about freedoms of speech and the press in the digital age. Until August 2016, Jaffer served as Deputy Legal Director at the ACLU, where he oversaw the organization's work on free speech, privacy, technology, national security, and international human rights. He litigated many significant post-9/11 cases involving human rights and national security, including cases relating to surveillance, secrecy, censorship, interrogation, detention, and extrajudicial killing. He led or co-led litigation teams that compelled the Bush administration to disclose the torture memos, compelled the Obama administration to disclose the drone memos, and compelled the National Security Agency to abandon its dragnet surveillance of Americans' cell call records. Jaffer's writings has appeared in the New York Times, the New Yorker, the Washington Post, and Foreign Affairs. He's an executive editor of Just Security, a national security blog, and his most recent book, The Drone Memos, was one of the Guardian's best books of 2016. I think all of us who care deeply about free speech, the rights of individuals, privacy, and similar issues owe Mr. Jaffer a tremendous debt of gratitude. We're thrilled to have him joining us this evening. Without further ado, please welcome Jameel to join us here on stage.
Thank you, Ellen. And great to see all of you. Thank you for the invitation. I'm glad to have the chance to speak to teachers, to thank you for your work. I'm sure that this is an especially challenging time to be a teacher. I know, for example, that you have to compete for the kids' attention with Miley Cyrus and Magic the Gathering, which can't be easy. But more seriously, there are political leaders all over the country, as you know well, who are demanding that we impose new limits on what subjects can be taught, what books can be read, and what ideas can be explored in the library and the classroom. I know that many teachers and administrators have valiantly resisted those demands, speaking out publicly, testifying before legislatures, and even joining in First Amendment lawsuits. As a citizen and as a parent of school-age children, and as a First Amendment lawyer, I'm very grateful to those teachers for their civic courage. So book bans and library purges are forms of censorship that are recognizable to us. First Amendment advocates know how to respond to them. Things are more complicated in the digital sphere. New technology has given us new possibilities for speech, but it's also generated new modes of suppression. The conceptual vocabulary and the legal frameworks that we developed to protect free speech in the analog era don't map very neatly onto digital technology. It's not always evident what should count as censorship in the digital realm, let alone what we should do about it. The institute that I direct at Columbia, the Knight First Amendment Institute, was established 8 years ago to develop and defend a vision of the First Amendment for the digital age. I had nothing at all to do with the timing, so I can say without any self-promotion that launching the institute at that particular moment was prescient. Few questions have been more debated over the past 8 years than the ones about free speech and new technology, and the ones about new communications platforms in particular. In its most recent term, the Supreme Court considered 5 cases relating to free speech and social media. Many First Amendment advocates, including me, worried about what the court might do with those cases, partly because the questions presented were genuinely difficult, but also because, as Justice Kagan observed at an oral argument last year, the 9 justices of our Supreme Court are, quote, not like the 9 greatest experts on the internet. But Justice Kagan needn't have set expectations so low. While there's lots to criticize in some of the court's other recent decisions, the court resolved these First Amendment cases thoughtfully. This said, it left some big questions about censorship online unanswered. It won't be able to avoid those questions for very long. Two cases the court considered this past term were about the social media accounts of public officials. In general, public officials can use social media just like other citizens. They can post photos of their friends, repost news articles, or even tweet about politics. They have a constitutional right to speak on social media, just as you and I do. But these days, many government officials use their social media accounts not just for personal reasons, but for official ones too. They use Facebook and Instagram to announce their official decisions and to explain their policies, to tell their constituents how to get help during natural disasters, or to let them know about a new vaccine. Ordinary citizens use the comment threads associated with these accounts to communicate with their representatives and with each other. You may remember that President Trump used his Twitter account to make cabinet appointments and engage with foreign leaders. Millions of ordinary citizens use the comment threads to respond to his statements, sometimes critically. When public officials use their social media accounts in that way, as extensions of their offices, they create online forums that are important to our democracy. And when they block their critics from those forums, as President Trump notoriously did, they suppress dissent that's socially valuable, and they insulate themselves from criticism that they should hear. Offline, the First Amendment prohibits public officials from excluding citizens from important forums, like school board and city council meetings, on the basis of political viewpoint. As I'm sure all of you know well, a school board can't eject people from their public meetings simply because they've disagreed with the board's decisions. The question the Supreme Court had to answer last term was whether the rule that applies to school board meetings applies to public official social media accounts as well. According to Justice Barrett, who wrote the opinion for a unanimous court, it does. If a public official is using social media as an extension of her office, she's subject to the First Amendment, just as she would be if she were hosting a public meeting in a city hall. In my opinion, that was the right result. It's a ruling that will help protect the integrity of digital spaces that play an increasingly central role in our democracy. But this isn't the last time the court will have to consider the implications of social media accounts run by government officials. Let me tell you about a case we're working on at the Knight Institute now. Like many other federal agencies, the National Institutes of Health, the NIH, maintains social media pages that it uses to communicate with the public, mainly about matters relating to public health. In the comment threads associated with these pages, ordinary citizens respond to the agency's posts, ask questions, and interact with each other. Sometimes they criticize the agency. At the Knight Institute, we represent animal rights activists who have strong views about federal agencies' use of animals in scientific testing. The activists sometimes express those views in the NIH's comment threads. In response, the NIH has deployed software that automatically deletes comments that use words associated with animal rights advocacy. Words like stop, torture, monkey, and cruel, and hashtags like stop animal testing. Any comment that uses one of those words or phrases is immediately suppressed. To all appearances, it's as if the comment had never been posted at all. The NIH actually denies that it's engaged in censorship. It says its keyword blocking technology is just intended to ensure that discussions in the comment thread stay on topic. But if the courts define censorship as narrowly as the NIH does, government agencies will soon have broad power to silence their critics online. Every government agency will be tempted to suppress inconvenient speech by labeling it off-topic, and keyword software will make the process costless, instantaneous, and invisible. The question of what constitutes censorship online is very much contested, and it's often difficult to answer. In this most recent term, the Supreme Court tackled another dimension of the question in a case arising from the government's efforts to suppress vaccine information during the pandemic. Over an 18-month period, government officials repeatedly demanded that social media companies take down content, sometimes berating them or vaguely threatening them with regulatory reprisal. At one point, President Biden told the press that the platforms were, quote, killing people by failing to suppress vaccine misinformation more aggressively. The question the Supreme Court considered was whether the Biden administration's actions were a constitutionally permissible effort to persuade, or whether they amounted to an informal scheme of censorship in violation of the First Amendment. Now, this kind of question has arisen before in many contexts, including, most notably, in a case that was presented to the Supreme Court in 1963. A Rhode Island legislative commission tasked with encouraging, quote, morality in youth. This was the forebear of some of the commissions that are stocking schools and libraries today. This commission was sending letters to book distributors, urging them to take objectionable books out of circulation and warning them of possible prosecution under the obscenity laws. To follow up on the commission's letters, police officers would visit the bookstores, visit the book distributors' offices to inquire whether the letters had been acted upon. And the Supreme Court held that the commission's actions were unconstitutional. The principle the lower courts distilled from that ruling is that while the First Amendment permits the government to try to persuade book distributors and other so-called speech intermediaries to reconsider their expressive decisions, it prohibits the government from coercing them. Persuasion is okay, but coercion isn't. That may seem like a straightforward enough rule, but it's proven hard to apply, and the application of it in the digital sphere to social media platforms is especially challenging. Social media platforms are particularly susceptible to coercion. For one thing, they're dependent on the goodwill of regulators. They aren't particularly invested financially or ideologically in the content of the posts that they publish. And they operate at such an incredible scale that the removal of any particular post doesn't significantly change the product they're offering their users. The consequence is that coercing these companies to take down speech is relatively easy, certainly much easier than it is to persuade a librarian to pull a book from the shelves or to persuade a newspaper to take down a particular news article. The major platforms are also particularly attractive targets for coercion. The biggest platforms have immense power over public discourse. Through their content moderation policies and algorithms, they determine not just what can be said and who can say it, but what ideas get heard. Government officials know very well that pressuring a small number of technology companies can help them reshape and control public discourse online. So all of that is to say that it's not obvious that the First Amendment rules that we developed in other contexts should be applied in the same way in this new one. In the vaccine misinformation case it considered this past term, the Supreme Court managed to avoid some of the most difficult questions by concluding that the conservative activists who had brought the case hadn't shown that the platform suppressed their speech because of government pressure. The court reasoned that the platforms might have taken exactly the same actions, even if the government officials had never contacted them. But the court will have to come back to this before too long. Government officials will continue to cajole and pressure the platforms because the platforms have a lot of power over what people can say online. I'll come back to that in just a minute. With the presidential election just a few months away, government officials will be especially concerned about posts that mislead people about their eligibility to vote and about where and when votes can be cast. Now, many of you are probably sympathetic to the government's effort to counter false speech about vaccines and elections. So am I. But whatever rules the courts develop in this context have to account for the possibility, for the certainty, that government officials will sometimes be wrong about which speech is false. It's also important to remember that whatever rules the courts come up with for false speech about vaccines and about elections will apply to allegedly false speech about, for example, war and social justice and reproductive rights. If you're considering giving government officials broad authority to suppress misinformation, don't assume that the officials will define misinformation in the same way you do, or that they'll focus on the same categories of misinformation that you and I think of as most dangerous. The last of the Supreme Court's recent social media cases, and the last cases I'll talk about tonight, involved social media laws that Florida and Texas enacted 2 years ago. Legislators in those states were upset by social media companies' decision to ban President Trump from their platforms after the events of January 6th. They responded by prohibiting the platforms from banning controversial speakers and from taking down controversial speech. Florida's law restricts platforms' right to suppress the posts of political candidates in the weeks before an election. Texas's bars platforms from taking down content because of its viewpoint. In court, the social media platforms argued that the laws amounted to censorship in violation of the First Amendment because they restricted their right to decide what speech to publish. The state said it was the platforms that were engaged in censorship by deplatforming President Trump and other conservative speakers. One federal appeals court sided with the platforms, another one sided with the states. I said earlier that the rules the courts developed in the analog era don't map on very well to the digital sphere. Because the most important spaces for public discourse online are owned by private corporations, two foundational free speech principles come into tension. The first principle is that private speakers and editors have a right to decide for themselves what speech to publish. The government can't force a bookstore to sell books it doesn't want to sell. It can't compel a newspaper to print stories it doesn't want to print. And the First Amendment protects the right of bookstores and newspapers to make those kinds of decisions for themselves. It protects the right of social media companies, too, to make those kinds of decisions for themselves. But the second principle, expressed particularly forcefully in the public forum cases I referenced earlier, is that the spaces that are most important for public discourse should be open to everyone, whatever their political views. That's important because the legitimacy of democracy turns on all citizens having access to the public square on the same terms. It's not a democracy if the only people permitted to speak in the public square are those whose views are favored by the government or by the most powerful private corporations. Our democracy won't function if the most important spaces for expression online are closed to political minorities. When democratically important spaces are owned by private actors, those two principles come into conflict. And that's what made the cases involving Florida's and Texas's social media laws so difficult. Justice Kagan, who wrote the decision for the majority, resolved the case narrowly, holding that the First Amendment doesn't allow states to override platforms' editorial decisions if their motivation for doing it is to advance their own conception of ideological balance. By resolving the case in that narrow way, the court deferred some of the harder questions. Here again, though, it won't be able to defer them for long. While Texas's legislators were motivated by a desire to restore what they saw as ideological balance to the platforms, Florida's legislators were at least arguably motivated by something different: the desire to ensure that Florida's citizens would have access to political candidate speech in the days before an election. The Supreme Court may have to say whether it should matter that Florida had different motivations than Texas did. The court will also have to say more about how the First Amendment applies to other forms of social media regulation. There are lots of ways of regulating social media that don't involve overriding platforms' editorial judgments. We could protect privacy, for example, by limiting the kinds of information that platforms collect about their users. We could make the platforms more accountable to the public by requiring them to disclose more information about their practices and policies. We could make them more accountable to users by requiring them to provide explanations to users whose speech they suppress or take down. And we could reduce the power they have over public discourse online by enforcing antitrust laws, making it easier for users to switch from one platform to another, and encouraging the development of new platforms. So I've been talking about social media tonight because these are the cases that the Supreme Court dealt with this past term. But the court will soon have to consider how analog era precedents apply to other new technologies. New surveillance technologies, facial recognition, for example, have the potential to deter people from participating in public protests and exercising other First Amendment rights. Artificial intelligence has the potential to further undermine the integrity of public discourse in the digital sphere. The distressing and ominous events of this past weekend only underscore how much is at stake here. As teachers, all of you play a vital role in educating young people about free speech and free speech values like tolerance and open-mindedness. Instilling those values is important work, as is fostering a broader culture that's conducive to free speech. But public discourse is shaped not just by individual and social values, but by law and technology, which help determine how we communicate with one another, whether we understand each other, how we negotiate our differences, and whether we can bridge political divides. Over the next few years, the courts will have an essential role to play in determining whether new communications technology serves democracy or undermines it. Thank you again for everything you do. Thank you for the invitation to speak, and thank you for listening.
Thank you so much. Particularly appreciate the conversation. This is actually making any noise. There it is. All right, excellent. So what we want to do now is turn into Q&A. We have plenty of time to be able to engage in the conversation. I'll be pulling a few questions from online as we have them, but would love to start with questions here in the room. What questions do you all have for Jameel? Let's start back here. And then come up here to the front. Right there.
All right, first off, thank you. I appreciated your piece towards the end about the potential use of antitrust laws. My first thing that I'm just curious about is whether or not the government has shown a willingness to address issues using antitrust laws, given that it seems that we have a small amount of companies in a lot of different areas nowadays, specifically around social media. And then if they were to use that, how could they best go about doing that, specifically around free speech issues?
So I should start by saying I'm not an expert on antitrust law, but the Biden administration has used antitrust law relatively aggressively. Lena Khan, who's now the chair of the FTC, has used antitrust law relatively aggressively. Now, American antitrust doctrine has focused since the 1980s on a narrow set of harms, consumer harms, that can be measured through dollar differences. And the kind of concentration that I'm most concerned about, just given my focus on First Amendment rights, causes a different kind of harm that's harder to measure in that way. I'm focused on concentration of power over public discourse, right? And that may line up, it does to some extent line up with market concentration in a more traditional sense, but not entirely. Like I'm not, concerned about Coca-Cola or Gillette. I'm concerned about Facebook and Instagram and TikTok, right? I think that there is enough overlap between the concerns that antitrust lawyers usually have and the concerns that I have here that it should be possible to use antitrust law to address the problem of concentration over speech, but I don't think that antitrust law alone is going to address the problems that I was referring to. I think we will need other tools, and those tools would have to include privacy regulation that reduces the power of some of these corporations over speech by reducing their monopoly over data, over personal data. Transparency mandates that make the platforms more accountable to the public. Interoperability mandates that make it possible for other developers to build on top of the networks that these social media companies have built. We probably need a combination of those tools.
So we have a question up here at the front.
So with the acceleration of deepfakes, and we've seen stuff like with the Taylor Swift leak several months ago and various other things, at what point do we cross a boundary between that being like satirical and protected by the First Amendment compared to being like an obscene and heinous issue?
A very easy question for you.
Yeah. Well, okay, so I don't know the answer to that question. I'll give you a framework for thinking about the question, okay? So in, I think, everyday conversation about the First Amendment, we sometimes say something is protected or not protected by the Constitution and mean people have the right to do it or they don't have the right to do it. The doctrine doesn't actually work that way. The doctrine works in two steps. The first question is the activity covered by the First Amendment? Is it protected by the First Amendment? Does it fall within the First Amendment's concerns? Then there's a second step, which is if it does fall within the First Amendment's concerns, are the government's reasons for regulating it good enough to justify the restriction of that activity? And I think there's no question that disseminating satirical or deepfake video online is protected by the First Amendment in the sense that it's covered by the First Amendment. It implicates the First Amendment. The hard question is, are the government's reasons for regulating it good enough to justify regulating it? And that is going to turn on the nature of the regulation, like how carefully drafted the regulation is. The problem with some of the proposals that have been put forward so far is that they don't just get at, what was your term, the heinous, the most heinous instances. They would also chill or even criminalize satire. And drawing that line is always going to be difficult, but the proposals that have been put forward so far, I think, go far beyond the category that you suggested you wanted to regulate and go well into the category of speech that we probably don't want the government regulating.
So the question you ask, or the two-step process that you mentioned about the First Amendment is very similar to the question that Mike asks online. He asks, what are some common misconceptions about the First Amendment that you believe teachers should address with their students? So thinking about many of the ways in which people may perhaps misunderstand the First Amendment, what are some of the most important ones that people tend to miss but should be emphasized?
Maybe the most important thing that people miss is that there's a lot of disagreement even among First Amendment scholars and advocates about what the First Amendment means. Like this is, there's a huge amount of disagreement among First Amendment organizations about the Florida and Texas laws that I referred to earlier. Most First Amendment organizations thought that the parts of those laws that required Texas and Florida to publish speech that they didn't want to publish, that those parts of the laws were unconstitutional. But the laws also included transparency mandates, and they also included provisions that required the platforms to explain to users whose speech was taken down why that speech was taken down. And First Amendment advocates and scholars have been very divided. Divided is actually too generous. First Amendment scholars and advocates have been all over the map when it comes to those provisions, because some people see the platforms opacity of the platforms, the fact that the platforms don't disclose anything to the public or very much to the public and don't disclose anything to users whose speech is taken down, some people see that as a challenge to our free speech ecosystem. They see it as, I say they, but this is actually my view. I think that the fact that platforms disclose so little to the public is a problem for free speech. We should see it as a First Amendment problem. And there are other First Amendment scholars who take a quite different view, and they think, these transparency provisions are an indirect way of censoring the companies, that if you require companies to explain why they're not publishing speech or why they're or why they are publishing speech, the effect is going to be to chill those decisions. The companies will make different decisions because they have to account for them to the public or to their users. And I think that this is actually a hard question. I think that there are good arguments on both sides, even though I think my side has a better argument. But that's all to say that I think that if you're not immersed in First Amendment debate, you might get the impression that there's this First Amendment community that that shares a set of basic principles about what the First Amendment means. And yes, there is agreement, but the agreement does not go as deep as you might, think or hope it would.
Other questions in the room? Show of hands. Let's go back to Kelly first, and then up here to Dave.
Good evening. So when you were talking, I will tell you what was kind of running through my mind is I was thinking about in the 90s when drug culture was rampant and society, people in the community were calling for Congress to do something, and then we end up with something and it's bad, the after effect. So I'd like that you're thinking ahead. My question is, I'm concerned about what you said about the right sort of to share information or what's disinformation. So I remember for a minute there were these warnings that would come up. You're attempting to share something you haven't read, or this has been fact checked. And so while I understand what you said, I wonder if meeting a halfway point would be if it was okay to leave those things for accounts registered to people under 18 or something like that, because we're still trying to teach media literacy and teach kids how to critically think. What are your thoughts about that?
Yeah, I actually love that stuff. I love the labels. I think it's a great idea for social media companies to label speech that they think is misinformation. The label ideally would, give people enough information or give them a link to enough information to judge for themselves whether the information provided was correct or not. I think labeling is a way of addressing the problem of misinformation that doesn't run into some of the problems of suppression. The labeling that you're talking about and that I like is labeling that the platforms themselves adopted voluntarily. We've never had a law in this country that requires the platforms to label speech as misinformation. And I think that a law that required platforms to label misinformation would run into, for good reason, a First Amendment hurdle, because inevitably the law would have to define the category of speech that counts as misinformation. And it's actually very hard to define misinformation, and impossible to define misinformation. You have to, I said this earlier, but when you're thinking about giving government officials the power to define misinformation, you have to consider the possibility that what they think of as misinformation turns out to be true, and not just in the sense that government officials will lie about what's true and false, so that does unfortunately happen. But even government officials who are operating in total good faith, may think this week that masks work and think next week that they don't, or the other way around. And I think we all learned this through the pandemic that some things that we felt sure were true one day, we felt sure were not true, a week later. And the government has to act on the information that it has. The CDC puts out statements based on what it believes to be true at that particular moment. But one of the reasons we trust the CDC to the extent we trust the CDC is that the CDC's statements are open to criticism by private speakers, right? And if we ended up giving the CDC the authority not just to say this is what's true about the pandemic, but also to silence anyone else who was saying something different, we would have much less reason to trust the government speech because it wouldn't be subject to the checks and balances that it's subject to now. So I think for multiple reasons, we should be very wary of giving government agencies the power to define misinformation or suppress misinformation. But I love that some social media platforms, have been labeling speech that they believe is wrong and pointing their users to speech that they believe to be true. I think it's great that Twitter has this, it used to be called Birdwatch and now has community notes, right, where people can comment on, provide context for posts that they believe to be false or misleading. I think all of that is great. It's those policies are adopted voluntarily by the platforms.
Do you think there's an extent to which the distinction between minors and adults is relevant in these kinds of conversations? So is there more of a case to be made for government action when it comes to speech issues as it relates to minors relative to, say, speech actions that are relevant to adults?
Yeah, yes, for sure. I think one challenging, conceptually, yes, for sure, the government has stronger arguments for regulating speech that is directed to minors or that minors have access to. I think one very significant challenge is it's difficult to restrict speech to minors without also restricting speech to adults. I also think that while the government's arguments for restricting speech to minors while those arguments are sometimes compelling, I think that it's hugely important for especially teenagers to have access to the information that is often available only online. And we all know there are all sorts of risks and dangers online. There's all sorts of misinformation online, and for that reason, I think some of the concern about minors' access to speech is well-founded. But it is also true that especially minors who are in communities where it's hard to get access to particular kinds of information, health information, sexuality, political information, sometimes the internet is it. And I think we need to be careful about restricting their access to information that could be immensely important to their development.
Dave.
I love a good First Amendment discussion, so thank you for being here. Is it working now?
You're good.
I think so.
Okay,
Yeah.
I'll just be loud. So I really appreciate your explanation of the NIH case. I can see that being used with high school students and generating a great discussion about whose interests are at play. I know there was one teacher this afternoon who said in her classroom, she doesn't have debates, she has deliberations, and I think that would be a great place for a deliberation. But I'm wondering, like any good teacher or even Supreme Court justice, what if we change the hypothetical a bit? So instead of an animal rights organization posting on the NIH platform, instead it was a group that was in a coordinated effort posting information about clearly debunked conspiracy theories, right? Bill Gates is injecting us with microchips instead of COVID vaccines. Or, going further, if it wasn't a coordinated group, but one person who has developed a computer program to continuously spam CDC or NIH message boards. How does that change the First Amendment calculus, and how would the Knight Institute handle those situations?
So, we brought a case, I guess 6 years ago, against President Trump. It was the first major case that we filed at the Knight Institute. We sued on behalf of, I think, 6 people who had been followers of President Trump's Twitter account, but had been blocked after they criticized him, or criticized his policies. And we had 2 oral arguments in the case, one before the district court and one before the Second Circuit. And these are the kinds of hypotheticals that came up over and over again in those arguments. And if you want to teach this issue to students, those oral arguments would be a great way of doing it. But as to the specific hypotheticals, so the second one is about spam, spamming an account with dozens or hundreds of posts. So I think that's a real problem. I think that it would make those accounts unusable or something close to unusable by other commenters, other followers. I think you could have a content-neutral rule that addresses that problem. A rule that says nobody can comment more than X times a day. And that kind of rule, like under First Amendment doctrine, a content-neutral rule is relatively easy to defend. A viewpoint or content-based rule is relatively difficult to defend. What the NIH is doing here, I think, is pretty plainly viewpoint-based. And for that reason, I think it's especially problematic and especially likely to get struck down as unconstitutional. But a content-neutral rule that said you can't comment more than X times a day, I think that would be relatively easy for an agency to defend, especially if they could point to a history of people commenting in the way that you described. Your other one was about conspiracy theories. So now let's take the spam out of it and assume it's just a single post, because the spam problem you can deal with through a content-neutral rule. But a single post, I don't see why we would want the NIH to have the power to suppress that post. I think that if somebody comments in that way, somebody at the NIH, and the NIH believes that other people are listening to that and acting on it, somebody at the NIH can respond and say, somebody has posted here that Bill Gates, what was it? Some crazy thing. Okay, injecting microchips. It's not true. This is in fact how our vaccine works, and they can provide that information. And I think that has 2 advantages. First, it will correct other people who might share the incorrect beliefs about the NIH's practices or the vaccine. But also, it would be hard to give the NIH or any other agency the power to take down that post without also giving them the power to take down a post that says, I read a study that says this particular vaccine causes this particular problem, and here's a link to the study which was published in Science yesterday. And we don't want the NIH to have the power to take down that post, right? So I think the better solution here is counterspeech. Government counterspeech. The government should respond to posts that it believes are false. And in general, I think even outside the context of social media, that's what we want the government to do, to respond with its own speech. There are, I think, very narrow circumstances in which it's not realistic to think that counterspeech is going to address the problem. For example, on the morning of an election, if somebody posts on social media, this particular polling station is open till midnight, when in fact the polling station is only open till 4 in the afternoon. That's something that is going to be hard for the government to address solely through counterspeech, because there's not enough time to make sure that the counterspeech gets to the people who need to get to it. And in those very narrow circumstances, I think it might make sense to give the government the power to punish people who post misinformation. But I think that has to be an extremely narrow category. First, it has to be limited to situations where counter-speech can't be relied on to correct the problem. And second, it has to be a situation where misinformation versus truth is very easy to evaluate. Something like 4 p.m. versus 12 p.m., you can evaluate. Something like this vaccine works or doesn't, I think that's much harder.
So I wanted to ask a question next, bringing the conversation a little bit closer to home. So the Knight Institute, located on Columbia University, there have been, over the course of the last handful of months, significant campus protests. So students protesting over the situation in Israel, between Israel and Hamas, and what's happening in Gaza. Lot to unpack about the potential situation, but also a lot that has to do with sort of First Amendment concerns, speech concerns, protest concerns, assembly concerns. Being located where you are and having that sort of up-close view of the situation, what are your thoughts there? What are things that people miss about the situation? But also, what are some of the areas where, from your point of view at the Knight Institute, there are significant First Amendment concerns that ought to be considered?
So this is a really big question.
And you have 144 characters.
Okay, well, so let me start. Let me start with this. So Columbia is a private institution. It's not bound by the First Amendment, but like most other private universities, it has a set of rules and policies that essentially incorporate First Amendment rules and principles. And the reason Columbia and other universities have those policies is that they understand that free speech is integral to their missions, that they are knowledge-producing institutions, and any knowledge-producing institution has to make sure that ideas are open to criticism, that every idea can be considered, that nothing is off limits. And so Columbia has a set of rules, which I think are good ones, that protect professors when they speak out on matters of public concern, and that protect students when they, for example, protest on the lawn between Low Library and Butler Library, which is where these protests have mostly taken place. I think that I've been a little bit frustrated with the way the national media has covered these protests, because I think that the sense you get from a lot of that coverage is that things have gone terribly wrong at university campuses around the country. And I do think that there have been incidents, even at Columbia, that are fairly characterized as things have gone wrong. But for the most part, the protests at Columbia have resembled very closely the kinds of protests that have taken place at Columbia for a long time. They took place at Columbia around apartheid in South Africa in the 1980s, more recently around the university's investment in fossil fuels. In 1968, there were protests on Columbia's campus that included the student occupation of 5 different buildings. Students briefly took a dean hostage. It was, 1968 was very traumatic for Columbia, and I don't think, anybody thinks that, nobody wants a repeat of 1968, but compared to 1968, what we're seeing now on campus is relatively mild. And not just, is it mild, but I think it's entirely appropriate and a good thing that students are out there protesting. Students, across the political spectrum felt very strongly about what happened on October 7th and feel very strongly about what's happened since. You want students to feel strongly about stuff like this, and it would be weird if students didn't come out and protest. It'd be weird if on October 7th and 8th there weren't students on campus out there expressing solidarity with Israelis, expressing horror at the attacks. And I think it would be very weird if there weren't students out there now protesting the bombardment of Gaza. So I don't see it as, in the way that some national media are portraying it. And so that's the first point. I said that there have been incidents in which, that you can properly characterize as, incidents in which things have gone wrong. There have been incidents in which, people used anti-Semitic language against particular students or student groups. There have been incidents in which, there's one incident in which students used military, not tear gas, but something like tear gas on campus. There have been instances in which progressive Jewish students have been called anti-Semitic names by conservative Jewish students. There have been instances in which professors used anti-Semitic or Islamophobic language. So I don't want to deny that those things happened. They definitely did. The harder set of questions, though, I think, don't have to do with those kinds of incidents. They have to do with the use by some students of slogans and symbols that the other side sees as either discriminatory or even a call for violence, right? So on one side you have some Jewish students who hear some pro-Palestinian students using phrases like river to the sea, and hear those phrases as a call to genocide or a call for discrimination. And then you have some pro-Palestinian students who, or even Palestinian students, who see the Israeli flag and associate the Israeli flag with the elimination of their people. And I think, all of these people are approaching this in good faith. The question is, what do you do when students say, those other students are using language that I hear as a call for discrimination or violence, but those students who are using those phrases say, that's not what I mean, And this is actually a difficult question for universities because there's a federal law, Title VI of the Civil Rights Act, that requires universities, I think appropriately, to take action when there's discrimination on campus or where there's a hostile environment on campus. And all these students are coming to the university saying, this speech that other students are engaged in is creating a hostile environment for me. And universities now have this law that, by its text requires them to take action in response to complaints of discrimination. And on the other side, they have the First Amendment or their commitment to free speech, which requires them to ensure that no idea is immune from scrutiny and to ensure that political debate is robust and wide open on campus. And you have this conflict, or at least this perceived conflict, between the university's commitment to anti-discrimination and their commitment to free speech. And I think that, I don't think I can provide a full answer to this question here, but I think that, part of my concern over the last 9 months has been that universities, in their fear of liability under Title VI, are suppressing speech that is protected by the First Amendment. Some of that speech is controversial, some of it some students and faculty find offensive, but it is protected by the First Amendment. And my concern is that this reading of Title VI, this broad reading of Title VI, is resulting in a narrowing of legitimate political debate. And it won't be limited to this set of issues. It's not going to be limited to Israel and Gaza. It'll be all sorts of issues if you accept that Title VI requires universities to suppress speech in this context.
With that, please join me in thanking Jameel Jaffer for joining us this evening.